The idea we had, we've been in business now since 2006, was to try to take jaded third-year law students. I don't know how much you know about law school, but the story goes, the first year we worked them to death. The first year we scared them to death, second year we worked them to death, third year we bore them to death. And so the idea was to actually try to offer some unique opportunities to people who were in the third year program to try to provide a kind of capstone for their legal education. And by capstone, I mean a way of actually bringing together all the stuff, a lot of the stuff that they had learned in their substantive classes, torts, contracts, con law, criminal procedure, all that kind of stuff, and bring it in a new context where they would actually be doing something different, be learning new skills, but actually drawing on and building upon their first 2 years of law school in a way that would provide them a kind of look or window into real life experience. And I think we've succeeded really well. What we do is we take a group of between 12 and 16 third-year students who have done very well, can write very well, and are very highly motivated, and throw them into the water and watch them learn to swim. Right? No one sinks. We've made sure of that. And what we do is we provide them real cases before the Supreme Court, and the students actually take primary responsibility at every stage of the proceedings, except the last one. And I'll explain that in a minute. So as many of you probably know, to get a case heard before the Supreme Court, you typically have to go through 2 rounds. There are a beauty pageant and then an argument. The beauty pageant is just to persuade the court to take your case. Every year, the people ask the court to review about 7,000 cases. It typically hears around 70 cases a year. For those of you who are good at arithmetic, that means the success rate in getting your case heard before the Supreme Court, that doesn't mean you win it, just heard, is about 1%. Our rate, the last time I looked, or statistics were run out, was about 30%, which was the second best in the country, and that's second best among all non-governmental law entities. So among all law firms, things like that, but excluding things like the Solicitor General's Office, the United States Department of Justice, the government's lawyers, and things like that, they have a higher rate, understandably. So we do pretty well at that first stage. We get around 30% of our cases the court agrees to hear. And then we go through a whole nother round of writing where we try to persuade the court that now that they decided to take our case, that we should win it, that our position is right on the merits. Now the students do all the heavy lifting, all the major work at both of those stages. They do all the research. We, of course, help. We supervise. They do all the initial drafting. They do all the revising. They do all the polishing. And at that point, I or the other directors will start leaning in, if you will, a little bit more. And after they do all the sort of fine-tuning on it, we send it off to the Supreme Court. And then the Supreme Court sets a date for argument. Unfortunately, the students can't do that. They're not allowed to do that. I'm sure some of them could do it very well, but one of the real lawyers has to get up and stand before the court. In fact, the court is so jealous of its prerogatives that it won't even let us mention the names of the students who worked on the case in a footnote or anything like that. That's viewed as bad form. So the students remain pretty much completely anonymous throughout the process, but they actually learn a lot. And part of the learning experience is not only representing real clients in real issues that are cutting edge. By definition, almost anything that gets to the Supreme Court is cutting edge, right? There are probably pretty good arguments on either side of it, and it's a pretty pressing, important area of law. Otherwise, the court wouldn't waste its resources when so many people are asking it to hear so many different cases, focusing on it. And they're going up against some of the best lawyers in the country. Our most common adversary is the Solicitor General's Office, United States Department of Justice. We've beaten them more than they've beaten us. We've gone up against the Dean of the Business Bar of the Supreme Court. We beat him. Not as if we win all the time. We do have a very good win-loss record. We've argued 14 cases. We've had results in 12. And if I remember correctly, we've won 8.5 of those and lost 3.5. Half, you ask, how does that happen? It's what's known as a classic split decision. There are two issues in the case. We won one, we lost the other. Go figure. Better than losing them both, I guess. So, we've done very well, but we provide this experience where students can go up against people who are not only real lawyers, but are also typically very far into the business and very successful at it. So a few years ago, our team had to have a conference call with the people involved on the other side. So we're sitting in our seminar room. Everyone's on their laptops. We have a speakerphone on. We're sort of talking people. And all the people we've never seen before introduce themselves over the speakerphone. I don't know. The students are a little bit interested. I don't know what they're doing. And about 2 minutes later, one student raises her hand and starts passing the computer, her laptop, around to all the other people. And it comes to me, and basically what it says is, do you realize that the most junior person we are talking to is a partner at the law firm? Right. So here we have third-year law students going against people who've been in the profession in a very successful way for at least 6 or 7 years, something like that. So it's great for them. That really expands them, tests them, challenges them, and they learn an awful lot. And it's a whole lot of fun. Let me spend a moment just telling you about the kinds of cases we do. We do a little bit of everything. We do criminal cases, we do criminal procedure cases, we do bankruptcy cases, we do arbitration cases, we do labor law cases, just about everything you can imagine. Let me tell you about a case I worked on, and the clinic worked on with me this year. We had the thrill of arguing the first case this term before the Supreme Court on Monday, October the 2nd. It's a fairly important one, it turns out. It's called Epic Systems Company versus Lewis. Has anyone heard of it? Know about the issue? Concerns, as you know, from like credit cards and everything else you do these days, companies are asking everyone to sign as part of the fine print arbitration agreements so that you will agree to adjudicate any kind of disputes that you have with the company through arbitration rather than through a standard court case. The companies defend this. They say it's cheaper, it's quicker, it's better for the consumers. Consumers typically don't really believe that, but there's an argument about it. But there's this act in the background called the Federal Arbitration Act that says that once you agree to arbitrate, you pretty much have to, in the courts, enforce that. There's also another law, which comes, a series of laws that go all the way back to the New Deal, in particular the National Labor Relations Act and the Norris-LaGuardia Act, which protect workers' rights to collective action. Right? They say that workers, they can strike, they can do all this other kind of stuff. They don't have to pursue disputes individually with their employer. And it protects concerted activities for mutual benefit and protection. That's the statutory term. So the question here is whether an employer can actually force, through an arbitration agreement, employees to basically waive their right to pursue collective action. Basically, you sign away, you agree in the small print of these contracts typically, not only to arbitrate any dispute with the employer, but to do so individually, not collectively. And also, in many cases, you will do it confidentially, meaning you cannot tell anyone else, your co-employees, about your pursuing arbitration against the employer, what the issue is, what the dispute is, which, of course, hinders any kind of informal aid. If you can't tell your friends at work about it, they can't even give you emotional support, that sort of thing. So this turns out to be a big case. These kinds of arbitration agreements cover tens of millions of people across the country. The proportion of workers being covered is growing and growing and growing every year as employers see the advantages of this. So the National Labor Relations Board basically said a few years ago, took the position to be an unfair labor practice for an employer to force these kinds of agreements on employees because it interfered with their right to seek collective action. And of course, employers are pretty unhappy with that, and they started seeking review of what the National Labor Relations Board was doing. In the Fifth Circuit, they won pretty much a slam dunk. In the Ninth and Seventh Circuits, the employees won. And so there was the law, and the Sixth Circuit turns out the employees won as well. So the law was being applied differently in different parts of the country. It's a very important thing, affected a lot of people. And also employers had a lot of flexibility about which courts they could challenge the NLRB's rulings in. So what happened is that typically, for any large corporation, you could, if they have much business at all in the Fifth Circuit, which covers Texas, Mississippi, and Louisiana, they could go there and ask the court to review an adverse ruling from the National Labor Relations Board, and they typically win, because the Fifth Circuit had already said that it agreed that the Federal Arbitration Act basically trumped the National Labor Relations Act. So there's this conflict. We went up to the court. We had the argument. It was thrilling. The first Monday in October. The students were there watching. Although they weren't allowed to actually argue it, they were involved in preparation for the argument, doing research, but also perhaps more for more fun, they mooted me. So they pretended to be justices on the Supreme Court and asked me questions. So, someone would be ventriloquizing the notorious RBG. Others would be ventriloquizing Justice Kennedy, that sort of thing. And it was just wonderful to realize after the argument that when someone when someone had asked me a question in the mooting, and some justice somewhere during the argument had actually asked the same question, the student was just like over the moon. Yeah, as you can imagine, just like, hey, God, I could be Justice Kennedy, right? that kind of thing. So we're still waiting for a result. We haven't heard yet. It's thought to be one of the more contentious cases of the term. It's now the oldest case that hasn't actually been decided yet, largely because it was the first one argued of the term. But the court will almost certainly decide it before the end of June. So, and it'll get in the newspapers, I'm sure, however it's decided. So keep your eyes open for that. But it was a really fun experience. Students enjoyed it. I enjoyed it. And everyone learned a lot. So what can I tell you about the clinic? You must have questions. Yes? 2 questions. All right. Okay. First thing, basically, what do I think is going to happen in Epic Systems? Most people think that the deck is stacked against us. The one very odd thing happened at the oral argument. You'll remember, if you were reading the newspapers last April, when Justice Gorsuch came onto the bench, that he started with a bang, not a whimper. He was asking lots of questions all the time. Some people claimed he was annoying his colleagues. He was writing lots more opinions, dissents, individual concurrences, and things like that than any other justice had. In fact, he wrote, and I think he was on the court for only one sitting, so 1 month, and he wrote as many individual, not opinions for the court, but individual opinions as Justice Kagan had in her first 2 years. So he was really eager to get out of the gates. He was talking. Some people thought he's talking too much. Was a little bit of a loudmouth or whatever. So we went in thinking that, wow, we've got to be prepared for him. And he didn't say a word. I don't know what that means. He asked a lot. He said a lot in the next argument that came up right after ours, which was a big immigration case. So who knows how to read that. I think Justice Thomas is very pro-arbitration, so although he didn't say anything, I don't think he needed to for us to tell how he's likely to vote. The 3 other conservatives said things which indicated that it's going to be hard for us to get their votes. The 4 liberals basically seemed supportive. And in fact, Justice Breyer at one point said, I don't know if it was to me or to the other guy, one of the people on the other side, said basically, well, if we take that position, doesn't that mean that we're really just throwing the New Deal out the window? So I just want to stand up and applaud him for pointing that out. So I think it's probably going to depend just on Justice Gorsuch. And you might say, he's known as a conservative. Conservatives tend to side with the arbitration in these kinds of cases, not uniformly, but pretty much. But again, it's very weird for him not to say anything, so who knows? The other question was, how do we persuade people to give up the cases? By telling them, 1, the price is right. We're free. 2, persuading them that we can do a really good job. 3, reaching out and offering to work collaboratively with people. We're not really so much interested in taking cases over from people and just sort of doing them ourselves. It's much more fun and beneficial for the students to actually learn by working in some ways with the attorneys below. Right? So we want to respect everything that they have done. We want to include them if they're interested. Some of them aren't. We want to include them if they're interested in everything we're doing. But it's basically, though, the price and the expertise that are the selling points. More questions? Yes?
How do you decide which cases to take up?
Well, we want to take up cases that stand a good chance of going the whole way. Right? And so there are some traditional indicia of that, like a conflict among the lower federal courts of appeals. So the Supreme Court feels rather strongly that federal law should apply the same across the country. You don't want a different federal law for New York than for California, that kind of thing. So circuit conflicts are often very important. In general, if it's an issue that concerns a lot of people, a lot of money, that will probably move it up in the court's hierarchy of importance. But it's very hard. The court, it says, is only going to hear about 1% of all the cases that people ask it to. So it's going to be very careful about how it allocates its resources. And so you have to basically convince them that for some reason your case is in the top 1%. And that's pretty hard. But the way, so disuniformity is one way. The stakes are another, the number of people affected by it. Sometimes it's just the symbolism of it. So there's some cases that the court has, is eager at certain times to hear, even though on the ground they may not be that important. They're sort of symbolically important, kind of thing. So you sort of work with all that kind of stuff. Yeah.
I was wondering, since there's so much controversy, even if the court decides against your position in this Epic Systems case, do you think there will be some hesitation for law firms and other organizations to use arbitration clauses, or no?
No. Do you mean law firms advising their clients to use arbitration, or do you mean law firms using arbitration themselves? Well, that's a different question. I don't think it will be. Law firms, if they're thinking of using it with their employees, many of their employees, especially the lawyers, are pretty legally sophisticated. So that's going to be a different kind of concern. As a matter of fact, I don't know how many law firms now are using this. That's a very interesting question. You can see it going both ways. I mean, one, the attorneys, to the extent that they're the ones who are being covered, sort of know what's happening, how it matters, what kind of difference it makes. On the other hand, the law firms know that, well, this really makes a difference on the ground to how quickly you can make disputes go away, whether someone even bothers bringing a dispute against you, that kind of thing. So no, that's a very interesting empirical question. I don't have a clue going forward, and I have not much of a clue right now. Yes?
Of the 12 to 16 students who
Majority clerk. Okay, not all, but the great majority of them do. So right after law school. Years after that, ones that they're doing different things, few are teaching, a lot are in practice, some are in politics, in some way or another. But I don't know that profile, the sort of 10 years out profile, differs that much from the general profile of alums. That would be hard, and I'd have to think about that and do some study. Yeah.
I was curious of how many already had federal clerkship or like clerkships lined up for after 1L or 3L prior to taking it, or if this clinic helped them get those clerkships.
It depends on the judge, and it depends upon when the judges choose clerks. And that has changed over the time of the clinic's been in business. There have been some times when, a few times when judges weren't actually picking their clerks until after second year grades came in. And so they'd be interviewing it typically at the end of the summer, right before the third year started. And in those cases, people in the clinic reported that it really seemed to make a difference. Because they could go, one of the things they had to do then, not so much now, but then, was they actually had to read all the cases coming down from the courts of appeals to try to spot cases that might be interesting for the clinic to take over. And so they would often know what the docket of the circuit was like better than the current clerks there. And that was impressive for a judge. But also, the judge, this is just something unusual on their transcript. Nowadays, it's a little bit different. So a lot of people have clerkships coming out. But especially for the Court of Appeals, some of those judges want people to be out, get some experience elsewhere first. So it's not as if it necessarily makes that much difference now when they're choosing in the second year, before students have even been admitted to the clinic, their first set of clerks, or the clerks that you would have right after you graduate from law school. But when people are later actually applying for clerkships after that, so not right when they get out of law school, maybe the next year or the year after that, it seems to help a lot. If nothing else, it sort of distinguishes you from the rest of the pack, but it's something real interesting. And certainly at the level of the Supreme Court clerkships, it makes a big difference. Yes?
How do you choose the students? What's the application process look like?
So students have to apply. It's unlike any other law school class where basically it's sort of random. People, you take like the people who apply, and then if more people apply, then you do it sort of randomly. But so we're looking for people who are really smart, really highly motivated, and really good writers. Okay? Now, we're also looking for a certain kind of substance matter diversity, because and also a little bit of substance matter focus. So half the cases we do are either federal criminal law or federal criminal procedure, probably a little over half. And that's true of the docket of the court. Right? And so it would make no sense for us to have a clinic full of people, none of whom had taken federal criminal law or federal criminal procedure, right? That would just be dumb. On the other hand, we don't need everyone to have focused on that kind of stuff. We probably want everyone to have some experience or exposure to it. Also, there are other classes like federal courts, civil rights law, which are a little bit like that. But then there are also some areas where every 2 or 3 years, the clinic will have a case that's in an area where, honestly, it's possible that if you didn't actually try to prepare yourself for it, you'd have no one who would know anything about the law. So for example, one case I'm working on now, in fact, the court is supposed to decide, will let us know maybe on Monday whether it's going to take it or not, is an ERISA case, which is, the ERISA is this incredibly complicated statute which regulates retirement benefits, healthcare, that kind of thing. Yeah, there's a class offered on it in law school. It's not the first one students like to take. So no one had taken ERISA. Now, luckily, I'm in a better position. For 20 years ago, I taught it. So I know a little bit about it, but I haven't kept up with it, really. But it's a real interesting question. even more important, the people who are going to be doing the work on the Supreme Court, the clerks there, probably none of them have taken it either, right? So it really, if we can, it helps to find someone who have at least one member in the clinic who has experience in sort of oddball federal areas like that, ERISA, bankruptcy, trademark, intellectual property, that kind of stuff that comes up occasionally. Now, there's some areas where we're probably never going to get a case. Patent is very hard for us to do, just because the stakes are usually so high that these super corporations, which have very deep pockets, are very happy to throw money at lawyers. So they want the most prestigious lawyers in the Supreme Court bar to do it, and the general counsel would never give a case like that to a clinic, even if it were shown empirically that we could do just as good a job as these other people, because if we were to lose the case, the general counsel would be criticized for going cheap on it, right? And so, but if you go with the leading member of the Supreme Court bar, that's one criticism you're never going to get, no matter how much he or she charges, kind of thing. So one more question, then we have to get you off to your next.
Thanks.
Yeah.
You said you've had 12 cases in 12 years of the clinic's existence. Has that kind of worked out one-to-one each year, or have there been years where there's been multiple cases?
Well, we had 14 cases. We've had 12 that we've got results in first, okay? The 1 year we had 4 cases. In fact, we had 2 of them on the same day. So I was sitting, I argued, came up first. I was arguing my case, and then Mark Santos, another director, was sitting at the table right behind me and came up. We just changed places that day. So it was all UVA all the time that day. Other times, especially at the year, I guess this is last year, after the death of Justice Scalia, the court just wasn't taking any cases, because it's much harder to get to 4 when you only have 8 justices, and it takes 4 votes of 4 justices to grant the case. And also, people were uncertain for a time whether the next justice would be a Republican or a Democratic appointee, right? And so that, I think, made them all risk averse. So they really weren't granting anything at all. So we went for, I think that's the only year where we've not had more than one, we've not had one case. Except for the first year, when we were getting started, we didn't have anything to argue then. Now, we say we have cases, those are the ones we've argued. We've had lots more, like getting in the pipeline. And typically, for us, we have to have 3, a little over, 3 times as many cases as we want to hear in the pipeline, just because the rejection rate is so high. But again, we're in a very good position because our rate is pretty high. Okay, thank you so much. I hope you'll seriously consider UVA. I hope you have a great time for the rest of your visit here. And if you have any more questions about the clinic, feel free to give a call or just send me an email. You can find both my phone number and my email address on the webpage. Take care. Thank you.